Greetings. Welcome to Navigating COVID-19 Issues, Legal Tips for Crisis Management of Small Business Entities. This video is brought to you by the California Lawyers Association, a nonprofit organization of lawyers throughout California. The video is geared toward an audience of non-lawyers and business people who have questions about how COVID-19 impacts running a small business. Please note that this video is intended to provide general information and does not constitute legal advice. The information in this video is based on the rules in place as of July 22nd, 2020. My name is Loryn Arkow. Welcome to our program. As you know, many small businesses are suffering crises during this pandemic. Revenues are down. Expenses keep going. There's a crisis of cash. What we're going to do today is talk with you about what you might do to address the crisis of cash and other problems facing your small business in terms of how you manage your small business. What is your authority to take certain actions without consulting other members of your company, or do you need a consensus? Presenting with me today is Whitney Skala from San Diego.
So in particular, what we're trying to help with today is to answer a few legal questions surrounding the legalities of how you might run your particular business entity. Plenty of businesses are formed as corporations or partnerships. They have to consult, of course, their bylaws, their articles, maybe specific contracts. But what we're going to focus on today mostly is limited liability companies. They offer the most flexible management structure, and they're starting to be used more and more often for small businesses. So we're going to spend our time today focusing on that. In particular, we're going to talk about the role of your articles, the role of the management agreement, and also the role of the revised Limited Liability Company Act. Riveting reading buried in our corporations code.
There are various decisions that you might be faced with now in managing your company throughout the pandemic that are decisions that you may not ordinarily need to address. You may have to decide to borrow to fill your cash flow gap. That might include an application for a PPP loan. You may instead decide to raise capital from your members to fill the cash flow gap. You may need to go to your lender or your landlord to ask for forbearance and negotiate a workout. You might have to consider selling assets or laying off employees. And then you may even be facing a dire consequence of potentially dissolving your company or declaring bankruptcy. These are all things that you have to consider whose consent is required to take these actions on behalf of the company.
So of course, these kinds of problems don't necessarily give you a lot of time to call meetings, present detailed presentations to your fellow owners or shareholders. But let's talk about a limited liability company and its management structure and how it would work during kind of crisis management times. So in a limited liability company in California, we have a manager, and sometimes it's multiple managers who have the power over the day-to-day decision-making, and sometimes it's quite a bit more broad. But the initial determination in how your particular limited liability company is run is whether the limited liability company is called member managed or manager managed. What's the difference? Well, in member managed, all members have this manager role as well. It's a dual role. So if you were in a situation of making one of these major decisions that we just listed, and you were in a member managed LLC, you'd have to get all your members to vote. It might provide for unanimous vote of the members as managers. It might provide for majority, but that's obviously a huge hurdle as opposed to being manager managed. Manager managed means that not all the members are automatically managers. In fact, it might just be one manager. You might be that appointed manager. And in that instance, you might have broad powers, again, going down that list we just discussed, to make those decisions. We talked about single or multiple managers, a varying degree of manager authority. Do you have the ability to make major decisions? Oftentimes, even a single manager, might only have the ability to make day-to-day decisions. If you are faced with borrowing money, if you're faced with selling assets, if you're faced with renegotiating major contracts or obligations of the company, as a manager, you might have to go back to the members for their approval. We want to talk about one more thing, and that's third-party constraints. So if you review your operating agreement, that's where you're going to find most of the answers to these questions of authority. You still might have third-party constraints that limit your ability to just make any decision that the crisis calls for. For example, you might have covenants in your loan documents. You might have restrictions in your commercial lease. These sorts of things might limit your capabilities to expand, contract, or renegotiate your obligations, and you need to consult those as well. This form here is, we talked about it, these are articles of organization, and this is the form in California that we use to form our limited liability company. But if your eyesight allows, if you look at section 4, that's where at the formation stage, the organizer is able to select and determine whether the limited liability company will be governed by one manager, multiple managers, or all the LLC members automatically being designated as managers. If you don't have this form on your computer somewhere or in your office somewhere, you can go on the Secretary of State's webpage, it's public record now, and you can look up this sheet for your own company. And by the way, others will look at this too. If they come to you and try to renegotiate a deal or an obligation, they'll want to confirm that you indeed are the duly appointed manager, and this is the beginning of that inquiry. This can be amended. So if the members don't like what it says, if they want more democracy, less democracy, want to vest the manager with more power, they can amend this document.
So it's really important to read your operating agreement and also your articles of organization to make sure they're consistent and to make sure you know your authority. Another place where this comes into play is when you're determining whether or not you can ask members to contribute more capital. Your operating agreement will indicate whether the members have an obligation to contribute more and when. Can it just be when the manager calls for it? Does there have to be a certain specific hurdle met? Who gets to decide? If all of the members don't want to make capital contributions and the manager can't force them to, sometimes a single member or the manager may have the ability to make voluntary capital contributions that are unilateral. And you want to check to make sure your operating agreement would allow for this before you go ahead and advance funds to your company expecting them to be treated as capital contributions. Advancing more capital contributions has implications for your capital structure. Will it dilute the other members? Will it subordinate their capital? So you want to pay particular attention because you don't want to put the money in and find out it's not treated the same way you expected. A manager might also, or a member may also have the opportunity to make a loan to the company instead of putting in more capital. That is often preferable because typically loans are repaid before capital. But again, is this allowed under your agreement and at what terms? You probably feel you're entitled to a risk-adjusted higher rate of return. Well, you can't go ahead and charge that to the company unless you would have the authority to do so under the agreement. Finally, another way to get capital into your company would be to admit new members and to have them advance funds. But You need to look at your agreement to see, does it allow for that? Do all the members have to consent to that? And on what terms would a new member come in?
So let's return to for a minute to loan documents. Now, again, what we're talking about here is not necessarily your operating agreement. You may have authority as a manager under the operating agreement to negotiate different deals with suppliers, with tenants, with whomever. But your loan documents may be a different story. So we want to make sure we're reminding you to go into your loan documents, look for loan covenants that maybe limit your ability to borrow additional money from third parties, that may limit your ability to take on more debt if you're if certain financial ratios aren't met, and certainly, you know, a little tension there because, hey, in troubling times, that is when you need the money, and unfortunately, that often is when you run afoul of those financial covenants. Look in your loan documents to determine if it's permitted to borrow from members, and if you can't borrow additional money, then borrowing from a member isn't permitted probably either. Do you have the ability to transfer interests or admit new members? Will that amount to a change in ownership under your loan documents and entitle the lender to call the loan? Then are you restricted under those loan documents from expanding your business opportunities or maybe even getting out of certain business opportunities? You'd be surprised what's in these loan documents, for better or worse, but your inquiry shouldn't just stop at your operating agreement. You need to move to your third-party documents.
Finally, we'd just like to note why all of these things are very important for you as a manager or owner of a small business. You could face serious legal liability if you don't follow these mandates in your operating documents. Your fellow members might sue you for acting outside of the scope of your authority. They may sue for breach of contract under the operating agreement, which might include an action requiring you to indemnify them for any negative fallout that might occur because of your actions. And believe me, that would probably extend to things, or at least they'll assert that it extends to things that are effects of the pandemic. Finally, managers of entities may be subject to claims of breach of fiduciary duty. And those types of claims apply to corporations, limited partnerships, and limited liability companies. A member or a partner might claim that the manager has breached its fiduciary duty and therefore owes damages to that member. Under the California Corporations Code, limited liability companies have two types of fiduciary duties that are imposed on managers. One is the duty of loyalty and the other is the duty of care. The latter, the duty of care, is the most important in this context, as it may be the case that one of your fellow members sues the manager, claiming that the manager didn't take care in the decisions that it made on behalf of the company. And this, since there are certainly problems involved in the COVID area, these managers may be subject to claims that their actions caused these problems. However, you can rest a little bit easier knowing that the standard of care under California law for this breach of for a breach of care is pretty low. It requires fraud or willful misconduct.
Loryn, you bring up some good points, and particularly on the breach of fiduciary duty. It's just so odd, isn't it, that you can, as a manager, try to do the best thing for the company and yet maybe come up a little short on whether you're fulfilling your fiduciary duty. Just need to be very upfront with everybody. As best you can, take your time and disclose and get the sort of approvals that you need under the operating agreement.
That makes a lot of sense, Whitney. Well, thank you everyone for participating. I want to just remind everyone that the information presented today is not legal advice and is based on the rules in effect as of July 22nd, 2020. We appreciate your watching this video and for doing your part to help navigate through the COVID-19 pandemic.